SJC-11598, Commonwealth v. Rene, Gosselin.
Mr. Reardon, you may begin.
Thank you, Your Honors. Attorney Theodore Reardon on behalf of Defendant Rene Gosselin. The first issue presented is that it was ineffective for trial counsel not to bring a motion to suppress for the defendant's Walmart optical medical records. Those records were obtained with a grand jury subpoena. The motion for new trial judge properly ruled that that grand jury subpoena was issued for an improper purpose and in violation of Rule 17. However, the judge granted no relief, stating that the defendant had not shown prejudice. But under the Kasner and Ogden cases, a defendant whose constitutional rights have been violated does not need to show prejudice. And here, the defendant's rights were violated because he had a Fourth Amendment right of privacy in his medical information. Relief is also appropriate for the second reason, that the court has its own interest in seeing that its grand jury authority is not usurped. But even if the grand jury subpoena was properly issued, it's insufficient because a warrant was required. This is analogous to the Carpenter and Augustine cases, where those courts found that those defendants had a constitutional right of privacy under the Fourth Amendment to their location information, and thus a warrant was required to obtain their CSLI. Here, Mr. Gosselin has an even greater Fourth Amendment privacy interest in his medical information. There's a substantial likelihood of miscarriage of justice for not bringing this motion because at trial, the Commonwealth cited to the Walmart records as linking the defendant to the eyeglasses that were found at the scene. And the victim's fingerprint was embossed in one of those lenses. The Commonwealth contended it was a bloody fingerprint. The Commonwealth used the Walmart records to link the defendant to the scene at the time of the murder. The second issue presented is that the defendant's CSLI was improperly obtained. It was obtained with a Section 2703 motion. While this case has been on appeal, the United States Supreme Court has decided Carpenter versus United States, which held that that motion is insufficient, and a probable cause hearing needs to be held with a search warrant issued. The Commonwealth has conceded that the defendant is entitled to the benefit of the Carpenter decision on this appeal. The reason why the CSLI of the defendant is significant is that it was essential to the search warrant that was issued for the defendant's house. In the affidavit in support of the search warrant, the trooper stated that the victim's CSLI was critical to solving the murder. However, the significance of the victim's CSLI is only apparent when it is read in conjunction with the defendant's CSLI. The trooper cited that the defendant's CSLI places his phone as bouncing off a cell tower very close to the victim's residence, and cited that as proving that he was there at the time of the murder. In addition, the trooper contended that the perpetrator took the victim's phone after the murder. And the affidavit recites how the victim's and the defendant's phones were both bouncing off of the same distant cell towers. And the victim's phone switched to another cell tower that is close to the defendant's house. Thus, the defendant's CSLI it was essential to the issuance of the search warrant, and everything else in the search warrant, everything else in the search warrant pales in comparison. Once that information is redacted from the search warrant affidavit, it's insufficient evidence to issue the search warrant. And the reason why that is significant is in the search of the defendant's house, the police found a Vans MacGyver sneaker box, size 13. And at the scene of the crime, there was evidence of a footprint of a Vans MacGyver size 13 sneaker. And the Commonwealth stressed that that box showed that the defendant owned the sneakers, the imprint of the sneaker that was found at the scene, the bloody imprint. And so the Commonwealth cited to both the defendant's Walmart records and to the Vans shoebox found in his house as linking him to the crime. And for all these reasons, the defendant's conviction should be reversed and a new trial ordered. That concludes my remarks.
Thank you. I'll turn to Justice Link.
As to your first issue, could you tell me why it is that you don't think prejudice is pertinent?
Why the what?
Prejudice. The prejudice factor is not pertinent. You're basically saying that the judge said, well, it didn't matter because he wasn't hurt by it.
Right.
And you say, well, that's wrong, and somehow I'm not getting that. Why would, we should be basically overturning a murder conviction because of a failure to do something that wouldn't have made any difference at all?
No. The reason why we say we don't need to show prejudice is that under the Kastner case, the court held that evidence is normally admissible absent a showing of a constitutional violation. And here there is a violation by virtue of the fact that the defendant had a Fourth Amendment privacy interest in his medical records. So we don't need to show prejudice is our contention. But again, our second contention is that the court has its own interest in seeing that its grand jury subpoena power is not being abused. And, the record does show that the Commonwealth has been issuing these kind of subpoenas for years. And the Commonwealth maintains now on appeal that it was completely proper. So if this is going to continue unless the court does something about it.
Okay, thank you. I don't have anything else.
Justice Graziano.
Mr. Ray, good morning. A few questions on with respect to the sufficiency of the affidavit in the D order showing probable cause. Did it show that the defendant was the last caller to the victim, a drug dealer who used his cell phone to deal drugs? In that the victim's cell phone was absent from the apartment.
Are you referring now to the 2703 affidavit, or are you referring to the search warrant affidavit?
The 2703, the so-called D order, the affidavit that you mentioned.
No, that is contained in, let's see here, on Appendix Volume 2, pages 36 and 37. There's a dearth of information there about the details of the phone. The affidavit doesn't articulate why this particular phone number that they're talking about is in any way linked to the murder. It doesn't discuss any of the details of how it's possibly relevant as distinguished from the other phone calls on the victim's phone.
It shows he was the last call, right?
Let's see.
Forgive me, I read this last week, so I'm not remembering it, but I'll look it up. Let me ask you, in the interest of time, let me ask you a different question, Mr. Rene. Is there anything left of the third-party doctrine in your view if we say that it doesn't apply to Walmart records?
Yes, I think so. I mean, I think the standards set forth in the Supreme Court decision that said that it depends upon the nature of the records held by the third party, and to the extent, it's revealing of the privacy interests of the person in question, there is a Fourth Amendment interest in.
Can we draw a distinction between traditional medical records and optical records?
No, I don't think so. They're all medical records, and there could be all kinds of in the history of the optical records call for the person to give a history of their background and their medical conditions, and who knows what kind of information could be revealed on there that isn't directly relevant, or the patient doesn't necessarily know the relevancy, but puts down all kinds of conditions.
And have you found in your travels and research, Mr. Rene, have you found post-Carpenter third-party doctrine cases involving medical records?
No, I have not.
Or certainly not optical records, correct?
Correct.
Okay, thank you, Mr. Rene. That's all the questions I have.
Thank you.
Yes, Mr. Reardon, I'm afraid I'm going to have to ask you about Griffin versus Kentucky and Figueroa, even though the Commonwealth has agreed as it relates to the Carpenter issue. Because you're saying that Figueroa is wrong and the footnote in Groom is wrong. I want to make sure I understand your argument. So if I can simplify it, you're saying post-Carpenter, since Griffin entitles the defendant to the constitutional new rule as long as the case was pending on review and doesn't require that it be preserved, no matter what we said in Augustine as it relates to the Declaration of Rights, now that we have Carpenter's view on retroactive application, that Figueroa and the Groom footnote is wrong. Is that your position?
I think the argument under the Griffin is that it refers to the federal constitutional.
Right, exactly. So let me be even more cogent. Since the federal Constitution is a bottom of protection, and Griffin doesn't require that the objection be preserved, is Figueroa and the footnote and Groom no longer applicable?
Well, as to federal constitutional issues, I'd say yes.
Okay, and how could the state constitution provide less protection?
Well, I mean, it can't provide less protection, but as far as I see what you're saying. Well, I think if the rule is not required by the federal constitution, the state can decide, whatever retroactivity provisions it wants.
No, I understand that, but the federal constitution is more protective, saying that you don't have to have it preserved.
Yes. Well, in the interest of the state cannot give less rights. There is an argument to be made that the court does have to apply its own rules retroactively.
Ms. Lee may be conceding that. I don't know. Okay, so Augustine comes out in 2014, right? The murder is in 2008. He's bludgeoned to death. The case is tried in 2012. The police officers do nothing wrong. They comply with the federal law, statutory law, the federal constitution, state law. They don't put everything into the search warrant because they don't need to. And now we find out that, assuming that the four corners of the CLSI affidavit don't constitute probable cause, we've got a suppression issue. Why does the Commonwealth lose that evidence when it has no deterrent effect? What's the point? What is the point of not applying the good faith exception to the exclusionary rule in this narrow circumstance where we have a limited number of cases left with this CLSI issue? What are we gaining?
Well, the question of a good faith exception was not in any way litigated below, and I don't really feel like I'm in a position, having not done the research, to state the contours of that and how it applies here. Just the Commonwealth didn't raise that below, and I don't feel like I've investigated it enough to go and say. Okay.
On the issue of the search warrant for the home.
Yes.
So you make the point about how powerful this CLSI evidence is in the search warrant for the home, and who's carrying the cell phone and where that's pinging off of, and that certainly is true as to the weight of that CLSI evidence. We don't really consider the weight of it, even though you're absolutely right. What we do is we excise it out, still see if we have probable cause. And I'm not going to spend the time right now going through the exhaustive list of everything else that constitutes enough for probable cause in the search warrant of the home. So do you disagree? Do you think that that very powerful evidence, which I agree with you, sorry to be redundant, it's really powerful, but that's not the issue. The issue is excise, do we still have probable cause, isn't it?
Well, I made two arguments in that. The first was that if you excise it out, there isn't sufficient probable cause, but I made an alternative argument.
That's a pretty steep hill, though.
I don't think so. I mean, they rely in great part on the victim's practices of who he let into his home and all that. And, I think most of that is fairly mundane, and most people do it. I mean, when someone comes to your house, you don't expect them to come unannounced. You want them to tell you ahead of time they want to come over. When someone arrives, they ring the doorbell. I mean, I think that's pretty normal for most people. But aside from the fact that I don't think there's probable cause if you redact this information, I did cite to this court's decision in Hall where it does look at it says that there is a situation potentially where there's certain evidence that is so overwhelming that that evidence is really the reason why the search warrant was issued, and the other information in there really was not the basis of the issuance of the search warrant. And it is an old case, but I think it is something that's worthwhile the court pursuing.
Okay. All right. Yeah, I think Call is maybe from 1975 or so.
Yeah, it's old.
Yeah, and all right. Thank you.
Thank you.
Justice Kafker.
Back to Justice Gaziano's question about the third-party doctrine and the glasses. So, you said, well, there could be a lot of information about all they have at Walmart is the prescription, right? What his prescription is. That's it. They don't have anything else about his eyes, right?
Oh no! Oh, he went in for a doctor's exam there, and it's in the appendix that those forms that Walmart uses ask you to go and state your medical history.
But were they trying to get his medical history, or they just wanted to get his prescription? All they wanted was the limited prescription information, right?
I don't think so. No, the warrant was the grand jury subpoena was broader than that.
Okay, all right. So you say it encompasses. Now, from what I remember, they already have that he's conceded that he may have left his glasses there, right?
Yes.
When they interview him, he concedes that they've got his glasses. I may have left my glasses behind on a different day, right?
Correct.
So they have his glasses, and I'm trying to do the second issue then, excising the CSOI. They have the indication from the other person's phone number, the victim's phone number, who the last person he spoke to. They also have information on, do they have cell tower information on that phone too?
On which phone?
The victim's phone, CSOI and the victim's phone?
Yes, they do.
And they also know that they're size 13 foot. Do they know the size 13 footprints?
Yes, they did.
And do they also know that he has size 13 feet at that point?
He had revealed that, yes. Wait a minute. I believe he did say he had size 13 feet, yes.
And the victim's blood is on the eyeglasses. That's all in the first affidavit, right?
Which affidavit are we talking about now? For the
affidavit. I'm trying to excise the CSOI information that you say was improper from the search warrant affidavit that got them into his house.
Yes.
So all that's in there with absent the CSOI, right?
Well, okay.
I'll be honest, I had trouble following the Commonwealth's brief of what's in and what's out. So
I wasn't distinguishing between what they knew and what was in the affidavit when you were just asking those questions.
So is it in the affidavit, all the things I just mentioned?
I don't believe so, no.
Okay.
I don't believe so.
All right. Okay, I have no further questions.
I've got a few. This is Chief Justice Gantz. What's wrong with an in lieu of subpoena? In lieu of appearance, furnish it, and then we will later review them and then submit it to the grand jury, especially after having identified which parts are relevant, which parts may be irrelevant or unfairly prejudicial.
Well, there's nothing wrong with the getting information ahead of time. The question is complying with Rule 17, which says that if you're going to get it ahead of time, you have to get judicial approval. And the second problem in this case was that the subpoena called for or said the person could alternatively comply by giving the information directly to the trooper who presented it, and there is no authority for putting that information in the subpoena. And Ogden, which is not a grand jury case, but which this court later held in preventative medicine applies to grand jury cases, Ogden held that it is improper to go and say in a subpoena that you can comply with this by handing over the documents.
Well, but Ogden, I believe, involved getting records that was after indictment, correct? That was
correct.
That were obtained from the jail with regard to the telephone records of the defendant?
Yes.
And I read preventative medicine, but in preventative medicine, the argument was that you can't, the defendants claim that Rule 17, the issue in preventive medicine was whether or not they could get a search warrant after indictment, and the answer was yes, you can search for whatever you want to. I know what the judge found, but I don't understand why it's an abuse of the grand jury if a prosecutor spares a witness from having to physically hand the records over at a grand jury, as opposed to saying, in lieu of appearance, we'll have the investigator pick them up and then we will later furnish them to the grand jury, which in this case they did. So what kind of abuse are we guarding against? Where, records obtained by a grand jury subpoena, the grand jury was convened, the records were furnished to the grand jury. Why is that something that we should be saying is not only wrong, but worthy of suppression?
Well, a couple of different things. First of all, putting aside the issue of preventative medicine, Rule 17 applies to grand jury subpoenas, and that rule states that you need to have prior judicial approval if the records are to be produced before a court date. In addition, the rule also states that the records need to be produced to the court. So that would be two important reasons why it's improper to do what was done here. But I think the Rhode Island Supreme Court also makes an excellent point.
If you're right about that, then every time a prosecutor would have no choice but, it's okay for a prosecutor to say, I'm going to subpoena records and have you bring it before the grand jury, correct?
I'm sorry, say that again?
Is there any, there's no problem with a prosecutor giving a grand jury subpoena to a witness, to the keeper of the records, and say, please bring your records to the grand jury. They're relevant to the grand jury investigation, correct?
Right.
So you're saying that if you're going to say, why don't you give them to the investigator, we'll spare you the trip that you have to proceed and go to a court pursuant to Rule 17?
Well, there's a couple problems with that. I think the Rhode Island Supreme Court made an excellent point that if you go down that path, it basically converts a grand jury subpoena into a warrant that's issued by the DA without probable cause, and that's highly problematic. But the other problem is that the grand jury is a judicial function, and the way the subpoena was issued in this case, it was issued with a clear understanding that it was going to be used to further the executive branch criminal investigation, and that's the judge made a finding of fact on that the Commonwealth has not argued is clearly erroneous. I think it skews the line between the judicial and executive branches by allowing a DA to essentially issue a search warrant without any probable cause, which the police can then use for months to further their investigation.
And have we ever said before that you need a search warrant to get medical records?
Well, no, but you also hadn't said before, Augustine, that you needed a search warrant to get CSLI, and that's the direction the case law is going.
Let's assume for the moment that there was not probable cause for the 2703, and let's put aside whether or not there was sufficient evidence if you were to exclude that from with regard to the search warrant that found the shoes. At trial, am I correct that all that the judge let in with regard to the location information concerning the defendant's cell phone was the city that it was in?
It was very vague. Something, yes.
So at trial, that evidence, the evidence of the victim's cell phone mattered, but he has no standing as to that, correct?
Correct.
So how was he prejudiced? Let's assume you're right about everything with regard to and let's assume that we say that the cell phone information with regard to the defendant's cell phone should not have been offered in at trial. What's the prejudice with regard to? I mean, if we exclude that, is there still prejudice from the evidence that came in with regard to the location of the cell phone at trial?
Well, no, but if you exclude that, then it means that the search warrant wouldn't have issued for the defendant's house, and they wouldn't have gotten the van's shoebox, which the DA used to link the defendant to the bloody size 13 MacGyver van's footprint that was found at the scene. So the CSLI per se was not key to the Commonwealth's case at trial, but it certainly was key to the issuance of the search warrant, which produced the van shoebox.
Okay. I have no further questions. Any other justice have any further questions?
I do, Chief. Follow up on the Chief's question about Chapter 277, Section 68, and the ability to have documents come to the grand jury without Rule 17. Judge McGuire had the same position Chief Justice Gantz has, right?
With regard to
the grand jury, the ability to have these documents come to the grand jury. His problem is that he found that it was for investigatory purposes and nothing to do with the grand jury presentment. But Judge McGuire agreed with the analysis that the Chief just gave as to being able to use the grand jury subpoenas, didn't he?
I don't think so, no. The motion judge ruled that the Commonwealth needed to comply with Rule 17, and he said that it was improper to have the records delivered without, in advance of a hearing without prior judicial approval. And he also ruled that it was improper to allow the records to be delivered to the trooper.
So let me ask you this: is that if we take all of Judge McGuire's factual findings relative to the purpose for which the assistant DA sought these records, do we have to draw the same conclusion that it was bad faith, or is that a mixed question of law and fact?
Well, I don't know if the judge made necessarily a finding of bad faith. I think he found that there was violations, and I think if the Commonwealth has not contested many of the findings of fact that the judge made, and I think the conclusions that follow from them are there's only one conclusion that can be drawn. Okay,
I'm not sure I read the judge's denial of the motion for new trial the same way you did. But Ogden specifically exempts the grand jury when it talks about Rule 17, and preventative medicine talks about the ability to use Rule 17 after indictment, but it doesn't preclude other means. Is that correct?
Well, I wouldn't say that Ogden exempts the grand jury.
Doesn't it say except for the grand jury?
No, well, it does, but it also says in that decision that that's just not an issue in the case, and we're not going to decide one way or the other. It wasn't a holding one way or the other relative to the grand jury, because the court said it's just not the issue presented in the case. So I would not say that endorses anything one way or the other about the grand jury.
And in last question as to whether or not there's probable cause after you excised the CLSI. My reading, and I think this might be on about page 51 of the Commonwealth brief and other areas as well. But my reading of what was in that search warrant for the house included much of what Justice Kafka referenced. But it also included that there was a bloody shoe print located in the victim's apartment made by a size 13 Van McGuire sneaker, and that the defendant wore size 13 MacGyver sneakers, correct?
I just can't say for certain one way or the other.
And that the defendant, the last call that the victim made was to the defendant and that the defendant had called the victim's phone shortly after that, and that was not CLSI information, that was subscriber information, correct?
There was a flurry of phone calls right at the end there, and one of them was to a lady Montero, and then was also talking with his friend whom he was going to spend the night with. So there were a flurry of phone calls right at the very end. Are you asking if the defendant was the very last person to speak with him?
Well, I don't know about the defendant, but the defendant's phone.
I believe that is true, yes.
All right. Thank you very much.
Thank you.
Any further questions for counsel? And hearing none, Ms. Reardon, thank you. And we'll turn to Ms. Lee.
Thank you.
May I proceed?
Please.
May it please the Court, Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. The defendant raises issues about the prescription for the defendant's glasses and the CSLI, which led to which he says led to the search of his basement that would get the Vance MacGyver shoebox. So that's where the defendant's claims are coming from. So the abuse of process at the grand jury claim goes towards the glasses, which were found under the victim's couch with the victim's fingerprint on the outside lens in what appears to be blood, and there's blood spatter on them. And those records show those are the defendant's glasses. And there's a bloody shoe print at the scene, size 13, and the defendant's shoebox at his home, which the search warrant was used to obtain. Excuse me, that shoebox was a size 13 Vance MacGyver's. And so that's the significance of these two issues. So the Commonwealth first point, I'm going to jump to the chase on the claim of abuse of process. While we disagree with the defendant's claim about an abuse of process and the judge's finding on the reason for the grand jury subpoena, I would point to Odgren. The remedy for an improperly issued subpoena is to properly summons the records, and these records were properly summoned for trial at transcript 8, pages 141 to 142. The Walmart Vision Center person testified in accordance with the trial subpoena, and defendant's record appendix 2, pages 104 to 105, shows the Walmart records that were presented at trial are not the same Walmart records from the grand jury. They represented the records, and so that's the remedy under Odgren. So the failure of counsel to bring a motion to suppress is not ineffective because it would have failed under Comida. And I would also note that the prosecutor in this case did not have the benefit of Odgren and preventive medicine, but he did comply with the spirit of Odgren and Smallwood because there were grand jury proceedings going on the day the subpoena issued, which was the issue in Odgren. There has to be a hearing going on. And actually the grand jury proceedings in this case began with its first witness the very next day. And these records were later presented to the grand jury, so Mitchell and Coate were also complied with, although they were not immediately supplied. A police officer testified on both May 8th and May 15th, Detective Sariva. You can find those records in the Commonwealth impounded appendix. He testified to the content of those records, and then on June 24th, the records themselves were presented. So I would suggest that there's no basis for a finding of an error in this case. I argued that the judge did not have a good basis for his finding against the prosecutor at pages 29 to 30 of my brief. And I suggest that there's nothing in the law that requires a search warrant for medical records. That would mean our statutes under Chapter 233, Section 79 and 79G are unconstitutional. Dwyer would be unconstitutional because victims' medical records are regularly obtained, even when they are privileged, without a search warrant. His next issue is the CSLI. I apologize that my brief wasn't clear. At pages 51 to 53, the bullet points show the probable cause was set forth clearly. It shows the last call the victim completed before he died was to the defendant's phone. It shows that his phone was moving after that call, and it was moving in the direction of the defendant's apartment. It shows the defendant had a size 13 shoe, and it shows that there was a size 13 Vans MacGyver sneaker print in blood at the scene, and it also showed their history. So there's plenty of probable cause without ever getting to the defendant's CSLI. And the judge strictly limited what could be presented at trial, that it was just the towns where the phones were bouncing off of the defendants and the victims, and the defendant can only claim error in accordance with his. So I would suggest there's no prejudice there. I'm also arguing for the good faith exception. I argue the good faith exception under the federal standard at the motion for a new trial in front of Judge McGuire. It's on the second to last page 142, and I noted to the judge that it doesn't apply in Massachusetts on Article 14, and that's consistent with Vasquez for preserving the issue. I'm happy to take any questions. I would just note one answer to Justice Gaziano's prior question. The D order affidavit does not show that the defendant's phone was the last call with the victim. It's a very thin affidavit in accordance with 2703D that does not require probable cause. And so I wanted to make that point clear. But I'm happy to take questions now.
Great, Justice Link.
No, I don't have any questions. Thank you.
Justice Gaziano.
What do we make of the issue involved in the whether the grand jury was convened or not for this purposes? And there's obviously an existing grand jury, there always is, but we have the prosecutor discussing the distinction between the investigation versus the grand jury's investigation. And this was done to further the criminal investigation for presentment to the grand jury. Or does any of that matter in your view?
Well, I think it's not relevant to the remedy in the case under Odgren. However, I don't mean to be dismissive of this court's interest in proper proceedings at the grand jury, and you can see from the Commonwealth record appendix that there were cases being presented on March 5th, which was the day the subpoena issued in this case, and in fact one of those cases was the presentment of records that were subpoenaed to grand jury. So I would suggest that the defendant's concerns that, this is something that's regularly done and is something that is clearly wrong, I take issue with, because the prosecutor here was trying to adhere to the law, but of course he didn't have the benefit of Odgren and preventive medicine. He did have the benefit of Coate and Smallwood and Mitchell, and all of those are complied with. And so he testified that he viewed a homicide investigation, a grand jury investigation, the police investigation as one unified whole, which I suggest is a type of sentiment that was echoed in the preventive medicine analysis. And Odgren itself says that grand jury is an investigatory body, and so the fact that it's being used for an investigation doesn't really tell you anything. So in this case, what the prosecutor did was he wanted to get the records quickly. During the defendant's statement, he made the statement, "I must have left my glasses behind, they must be under the couch." He said something along those lines. And then they already knew that he had called Walmart on the day of the murder regarding the subscriber records. So that's how they knew about the Walmart prescription center. And so they issued a grand jury subpoena and went to the police officer, and then instead of bringing them right back to the grand jury, they went to basically vet them. Are these the defendant's glasses or not? So that it could all be presented at once. And so if there's a concern that they should have been returned to the grand jury first, that's not something that shows bad faith or supports what the judge was finding, because the prosecutor testified he always intended to present those records to the grand jury. And I would suggest no other evidence at the motion for new trial hearing would support the judge's findings, as I said on pages 29 to 30 in my brief. Does that answer your question?
It does. Thank you. I have no further questions. Justice Lewis.
Yes. On the point that you were just discussing relative to the grand jury, did the testimony in this presentment begin the next day, though?
Yes, the day after the subpoena, the testimony came in from the defendant's brother, who testified basically about the defendant's whereabouts and whether he knew the victim, and but nothing about the Walmart stuff.
Okay.
And then you only have excerpts of the grand jury materials in the Commonwealth Record Appendix. That's what we presented to the judge at the motion for new trial. And it shows that on May 8th and then again on May 15th, the lead detective, I'm sorry, I'm not pronouncing his name right, Sarayeva, he testified about the contents of those records and that they were having them looked at through through an optometrist to match them up.
Mm-hmm.
So, and I would also note, there was a question earlier about whether these are medical records or not. Prescriptions are included in Chapter 233, Section 79G, and I think they're included. Optometry records may be included in another statute, which I haven't said in my brief, because I'm not specifically contesting that, because medical records are subpoenaed to the grand jury all the time. They are often mailed to the grand jury, and here the police officer went and got them from Walmart because they wanted to move quickly. And perhaps that's why the judge drew the inference that this was done in bad faith. But the prosecutor had testified that he always intended to present them, and there's nothing to suggest that he didn't want to present even exculpatory evidence to the grand jury because they wanted to get the right suspect.
I'm sorry, go ahead and finish, please.
No, that's okay, go ahead.
So if we accept every factual finding from Judge McGuire, is the determination that it was bad faith a factual finding or a legal conclusion or a mixed question?
I think it's a legal conclusion. You can see it at the defendant's addendum at pages 84 to 85. It's a carryover paragraph. And I think it's a mixed conclusion. I think you can look at from a factual standpoint, you can look at the transcripts on the motion for new trial and the evidence presented, and I think you will draw the conclusion, or I would ask the court to draw the conclusion that there's nothing to support Judge McGuire's finding of intentional error. However, I also suggest that because this was done in accordance with the law that was existing at the time, Coate, Smallwood, and Mitchell, that his conclusion is not supported under the law either.
So the question is how much we address this issue. I mean, all that would have happened if the evidence was suppressed is that you would have gotten the same evidence under Rule 17, correct? Mm-hmm. So there can't be any prejudice in this circumstance. My sense is, from my experience as a Superior Court judge, and you've been in more than one county, that there's different practices as it relates to the grand jury in this circumstance. So, is this something that there's a need out there post Ogden and to be able to resolve, or such that we should address it in preventative medicine, or since the lack of prejudice is pretty obvious, there's no need to?
In terms of the law as a state as a whole, I think particularly with the report from the Committee on the Grand Jury Proceedings, that there's now more advice on how to proceed before the grand jury, where there wasn't before. And as I said, Ogden and preventive medicine have come after. However, Judge McGuire has made a finding that the former prosecutor abused the process, which is, I think that's worthy of being addressed, and I would ask this court to reverse that.
Okay. Does Figueroa need to be reversed and groomed since Carpenter? Since Carpenter post Griffin now addresses the federal bottom of protection?
So I think in this case you don't necessarily have to address it.
Absolutely.
I did the application of Carpenter and Augustine as well, obviously, but of Carpenter to this case at the motion for a new trial, and I'm not going to go back on that, obviously. So I think in this case where the Commonwealth already agreed that, in fairness, the defendant should be able to raise the claim. I don't think you need to address it in this case unless you wanted to address it for the state as a whole.
I don't know about that, but I definitely want to see if you'll answer the question.
I'm sorry, I was meaning to answer the question.
No, I can understand why you might not want to, but we don't have to. We require that the objection be preserved, and it's in Augustine, it's in Figueroa, it's in the footnote.
Right, and so I look at it and I felt like Augustine hadn't even brought his motion yet. I understand the analysis in Broome, but it didn't seem fair to me to hold the defendant to that rule in this case, which is part of the reason I conceded it. Like, it's pending. Griffith versus Kentucky is going on. It's a constitutional issue, so why shouldn't he get the benefit of it? Which I guess would put me personally on the side of Figueroa and Broome are outliers, maybe need to be addressed and changed. But this court had its reasons for doing that in Broome, saying that the issue is out there and the defendant's attorney could have learned it, and his failure to do so means it wasn't preserved. And I know that was a big issue in the courtroom closure cases, and, you know, it was a big issue under Teague versus Lane. Now that Sylvain is out, this court has more room to decide what is preserved and what is not, and so I would leave that to the court. I felt like in this case the defendant should be able to raise the claim in these circumstances, but I would understand this court's ruling that Broome and Figueroa would have said my concession was ill-advised.
So I'm not asking you to concede this point, but I got the sense on the CLSI affidavit that your heart wasn't in it, and at best it's a close call. Am I interpreting your brief correctly?
Yes. So the D order complies with 2703D. The affidavit complies with it, and it's sufficient under that. So we didn't do anything wrong, but the D order is skinny. And so I looked at it, I tried to look at it, you know, dispassionately, just the words that are on there. It doesn't have that it's the last call between the victim and the defendant, which I think would have put us over the top. But it does have that the victim's phone is on the move after his death. And it does have that the phone that we wanted CSLI for had made many calls through the subscriber information, had made many calls to that phone. And so the inference there is that the killer would know that there's his evidence on that phone, and that's why he's taking it with him. Mm-hmm. And that's what I suggest you can draw probable cause from. I want to be candid with the court. It's skinny. Yep. It's not what you would put in a search warrant affidavit. The question here is it enough? And the answer is up to this court, but that's the argument that can be made from the information in the D order. Okay. Which is why I think it really shows why the good faith exception is needed in Massachusetts on this type of issue.
Well, let me ask you this. That very well may be, and you saw Justice Pfeiffer's concurrence and dissent in my concurrence, but if the search warrant with the CLSI excised is so strong, and you do lay it out in your brief, and I'm not going to go through it, such that there is no suppression of what's found in the house, is it appropriate to reach the good faith exception where we don't need to?
I think the question whether it's appropriate or not,
well, we don't need to.
You don't reach the constitutional issue if you can decide it without reaching the constitutional issue.
Yeah.
And so in that case, I have to agree with you, or agree with my own analysis that the probable cause is very strong even without the CSLI. Yeah. CSLI wasn't even an issue when Judge Cosgrove did the motion to suppress and made a statement. You didn't even need the defendant's CSLI for this. It's not relevant to it's not essential to the probable cause, I think.
Right, but the defendant's correct that, and I'm not saying that there's not plenty of probable cause in the search warrant for the home, but if there weren't, it would certainly create a substantial likelihood of miscarriage of justice considering what was found in the home. And you don't seem to
the shoebox is hugely important.
And you don't even make the argument otherwise.
I'm not suggesting that. So the CSLI affidavit in the affidavit of the defendant is not essential to probable cause, so you can affirm this conviction without addressing the good faith argument. And however, I think it's the appropriate issue under federal law that's already decided.
Thank you very much. Thank you.
Thank you.
Justice Kafker.
No further questions.
And I have no further questions. Are there any other questions from any of the other justices? And hearing none, that concludes the argument. I thank both Mr. Reardon and Ms. Lee, and to my fellow justices, we will plan to assemble the case at 12 noon. All right. Thank you so much.
Thank you.